Welcome back to Breakfast Central. We're still reaching you live from the Federal Capital Territory. It's day 3 of the Nigeria Economic Summit, NEST 31, and we're looking at the Reformation Initiative, building a sustainable and prosperous Nigeria by 2030. But so much has happened in the past 24 hours and more. First of all, news reaching us, like we started the show with, is that the Minister of Innovation, Science and Technology, Jeffrey Uchenaji, has resigned amidst rumors of forgery. There's been investigations carried out, and he's of course sent out his resignation to the president. The presidency has received his resignation in a post by Bayo Onanuga. Now, what are the implications of this? What is the next step forward? And then, we'll also be taking a look at the judiciary, the state of the judiciary. Recently, the NBA president, Mazi Afam Osigwe SAN, spoke about some of the challenges and opportunities that lie within Nigeria's judicial space. We hope to explore these conversations today on Breakfast Central. Now, joining us this morning is Senior Advocate of Nigeria, Monday Ubani SAN. Leonard, sir, thank you very much for joining us.
My pleasure. Thank you for having me. Thank you for having me.
First of all, maybe I'll start by saying congratulations on welcoming new SANs into the fold.
Yes.
It's a time for celebration indeed.
We are becoming a father in the business, and you are seeing your children grow up, and you're so excited. I was there live. I was there at the Supreme Court. It was quite an interesting event. And then, of course, you mentioned the speeches made by the stakeholders, the CJN, Chief Olani Kweku himself, who happened to represent the Bosan, and then the president of the bar, Mazi Afam. Beautiful speeches, So.
Mazi Afam's speech was quite. He made a lot of submissions that he talked about a number of things, including the SAN and the criteria for becoming SAN. We know that it's the pinnacle of your career as an advocate, right? If you're not looking to go to the bench, he talked about expanding the qualifications so that more people can be able to get the opportunity to become SANs. One of those categories would be, of course, the academics and those in the research. What are your thoughts on that?
Well, on the issue of the academics, people are saying that is an issue of advocacy. That if you are in the academics, you are not advocating in the court. It can be both. The highest you can attain in that ladder is being a professor. Are you following me? And then you have been a professor, you now want to also come and compete with those who are, really going to court virtually every day. So, that is academic. So it's not advocacy because it's senior advocates of Nigeria. And so the argument is, look, why don't you pursue that career in that line and all that? So they allowed only one every year, but people are asking for expansion, and then the academics themselves are saying, look, you are restricting us. Why don't you make us to be part of the entire process? So the argument is forward and back, but we believe at the end that those who are the major stakeholders will be able to come to that particular conclusion that will be fair, just, and equitable. It's very important, So, but for me, being a professor, they should pursue their professorship and leave us at the advocacy level. And that's my own. To the university
they compete for professorship.
Yes, exactly. We don't.
Perhaps talk about some of the things that we said there if we have time.
Many things that resonated. He mentioned the issue of the opportunity that is always looking like as if it's lost in the issue of pronouncement of the emergency rule. When the president imposed the emergency, he also dismantled the elected structures. And so many persons went to court in order to have the court determine that before the expiration of the tenure, of the suspension. Beautiful. So unfortunately, the courts were not willing at that time. So he mentioned it, that is a lost opportunity, because they may mention now that the matter is academic, but there has been a decision. There has been a decision recently after that particular speech at the Supreme Court, where the court said that those that came to court lacked locus. That it is only the Supreme Court that has jurisdiction over emergency validity. If you are challenging the emergency rule, the only court that can hear you is the Supreme Court, with its original jurisdiction.
So knowing this fact now,
yes.
If we had another state of emergency and somebody feels wrong, how better, or what advice would you give on how to approach the courts?
That is a very beautiful question. It's only the Supreme Court, and the Supreme Court determines parties Parties that can come to Supreme Court to invoke original jurisdiction are states and the federal government, or National Assembly and the federal government.
Does that involve the governors?
Yes, that involve is the governor. But the point now is that at the point the person is going to court, there is already an administrator that has been appointed by the president. The administrator will never give you leave to go and sue, challenging him. That is the problem. The governor who has been ousted does not have locus anymore. Jurisdiction. He can't go there as an individual to the Supreme Court to invoke the original jurisdiction. It's only the state and the Attorney General. So who gives you that authority to go and sue on behalf of the state? It is the administrator who has been appointed. So unless there is a constitutional amendment, the opportunity to challenge emergency rule and the dismantling of elected structures cannot be redressed in the court of law.
This is a dangerous precedent.
It is, if you ask me, that's why I said that unless there is a constitutional amendment. So the lawmakers have to sit down and say, look, do we intend to give the president the power if in the course of declaring emergency to dismantle elected structures? They can correct it. They can say yes. Because it started as a precedent, political precedent in 1962, when Tafawa Balewa imposed emergency rule in the southwest, and then dismantled elected structures, and nobody challenged it. Or there were some challenges and all that, but there was no success. Then Obasanjo now look at the books and started the same thing in 2004 and 2006. Other presidents preferred a situation where they preserve the elected structure, be a hybrid. You are very intelligent. And so that is Jonathan. The same thing with, who is his name now? Buhari. Buhari did not dismantle, rather Buhari increased what we call military presence in the states, where he thinks there is insecurity, right? But when President Tinubu came, he looked at the books, and he resorted to 1962 and Obasanjo's methodology. That is what happened. But people went to court and say, do you have that particular power? As a president who has been given power under Section 305 to impose emergency rule to also dismantle, that is the issue.
So now that the court is giving that judgment, is it possible for them to reinstitute fresh proceedings at the Supreme Court?
No. The point is that who will be the person to institute that particular decision at this point? Who will be the person? If he's the new governor, the governor who has been reinstated, now he becomes academic.
Yeah, so maybe not necessarily because they want a change, but just so that it serves as a point of reference.
Somebody has gone to court now, but the court now says, well, you don't have locus, but let's even decide a matter on merit. The court now went into the merit and said, look, there were circumstances under which the president had the right to have declared state of emergency. He also had the right to have dismantled the elected structure. The reason being that those who were implicated as stakeholders, the political class, couldn't have remained when an administrator is appointed because there would be a conflict of interest. There would be struggle again. You want to restore peace, and then you're allowing the governor, who is probably the problem of the emergency in the first place, to now work alongside with the administrator. So it will create a conflict. So he believed that the president was right in dismantling elected structures for 6 months. Yes.
From emergency rule, I want to touch on the conversation we had just before you came, which is, of course, we're looking at the INEC chairman, Mahmoud Yakubu, his tenure coming to an end, and him handing over to me, Agbamuche. One thing that was very prevalent in his time, or his tenure in office, was if you're not pleased, go to court if you disagree. And the courts had a huge role to play in past elections. And I want you to speak to the role that the court has played in terms of ensuring that they have been the final or the last hope of the common man in elections.
The problem is that the judiciary should have been the one to determine whether an elected officer has been validly elected. It is at the polling unit to decide who becomes an elected personnel for the country. But we have involved the judiciary so much that people call it judicialization of our electoral process, of our political process. It's not right. The court can only come in when there are irregularities in the process of election, and you find out that those irregularities can be redressed by judicial intervention. You go to the issue of everyone now going to court, even those who know they have lost that election. They know that they want to go and try their luck because anything can happen with their with the judicial system. So it is not right the way we are pursuing electoral matters in the judiciary. We are overburdening the judiciary in the first place. And we are making the judiciary to be the last, electorate in electoral process. Is not right. It is the people that determines who governs them. You can only go to the judiciary when there is some irregularities, and the court now can probably give a redress or ask for a rerun, but not that the judiciary should be the one to determine.
It's this judicialization of the electoral process.
That is a very good question. I think the best thing is making election to be really free and fair, and then those who go to court when the election is absolutely free and fair and very credible should also be punished. In making it very impossible for you to go to court, when it is for frivolous reasons. In Supreme Court now, if you are bringing an appeal on electoral matters, they ask you to go and deposit an amount of money. I did it. And then if your appeal is very frivolous, you lose that 1 million you have deposited. Maybe making it very, a bit, impossible. Because there are some lawyers who go to court on electoral matter knowing that is the shortest court to be a senior advocate. Yes, if you handle electoral matter from the first court of instance, the lowest level tribunal, up to Supreme Court 3, it qualifies you from the Supreme Court angle. Whereas if it's not electoral matters, don't handle it from beginning to the decision, is 4. Now the problem is that the good thing for electoral matter is that it's time bound, so they will hear it quickly. So many lawyers now use it now as the shortest court in order to fulfill the requirement of being a son. And so even if they know that there is no reason for them to go to court over the electoral result, they now want to go because it will help them to facilitate their process. Are you following me? So we are saying make it a bit more laborious for them. You pay a certain amount of money, for you to, if you know that this election is free and fair. So by the time we really ensure that there is credibility in an electoral process and somebody is going to court for stupid reasons, then he has to pay for it. So credibility of the electoral process is key. That is one of the way of discouraging people using judiciary to now give a final stamp to who becomes a leader or becomes a president.
Business, yes. Now let's talk about a very important issue, the wanton disregard for court orders in Nigeria. It impugns on the integrity and the sacrilegious, the sanctity and the sacredness of the judiciary. And we've seen this. We've even seen law enforcement agencies disregard court orders. Why are we seeing a rise in this, and why are there no consequences? Because the impunity is sickening. We just witnessed one recently with the Nigerian police on this tin permit issue.
It's one of the most unfortunate events in our judicial system, where judiciary will make a pronouncement and it's not been obeyed. I obtained a judgment over 15 years ago. A young man was shot by the Nigerian police, and he had to go and treat himself because if he did not, he would have died. He went to South Africa and came back, and we initiated an action against the Nigerian police. They never put up any defense, and judgment was given. I have done everything humanly possible in order to have that judgment enforced, to no avail. I have written to the Attorney General. Up to now, there has been no response, from the IG in order to, pay that amount of money that was awarded by the court. So it is a very worrisome situation that you follow a process, and then the number of years you spend in court, that is not taken into consideration. And then when you succeed in getting the judgment favorably, you cannot enforce it. Then why do you have to go to court? It makes people now to lose confidence in our judicial system. They say, why do I have to waste my time? Why do I have to, they use unorthodox in order to probably get justice. And so it's something that we need to sit down and address. The Attorney General, the major stakeholders in the judiciary must sit down. Do we get an arm of security outfit that can now be attached to the court that will now enable enforcement? Because relying on Nigerian police has been very, very, it's not successful. We have not had it good, especially when the security, personnel are involved in either Nigerian police or the army. You cannot enforce it. So we are saying we must take it as an emergency situation and say, look, the issue of enforcement of judgment is very critical for people to believe in our judicial system. Something must be done. It's either you are committed for contempt for disobedience, or there must be another arm that will enforce judgment. So something has to be done. Actually, it's a sad situation. It is not good for us. It's not something that we should, commend. It's something that will get us worried and all that. I believe it's a very vital point to raise. Yes.
Another issue that has dragged criticism, in the judiciary is politicians, the members of the executive, handing over gifts to politicians, to judiciary. The judiciary saying hobnobbing with the executive. How much of a problem is that, and how do we fix that?
It can pass with independence. The Constitution has actually made provision, elaborate provision for independence of the judiciary. Even with the issue of financial autonomy, is there in the Constitution. Now, the governors do not allow the chief judges of the states, to be in charge of the finance. They are the one that actually now put themselves in a position to dispense funds. They buy them vehicles, whereas the judiciary should be the one to determine whether they need those vehicles. They build houses for them and all that. And when you are doing that, you are making it look as if it is judiciary, it is executive money you are giving to them. It is their money that you are using to do all that. Why don't you allow them to control those funds and be in a position to determine priority? Well, this is what we need, whether it's houses or cars.
What's the global best practices? How's it done in our
global practice is that the judiciary should be in charge of their funds. They determine priority. It's not the executive that does that interference. Because by the time you pay, buy those things, you make it look as if it is, and of course, they expect favor in return. It really, really impairs on their independence, for allowing that actually to happen. So the best thing to do, if you ask, and I'm suggesting, is that the constitutional provision as to independence, both financial and administrative, should be enforced. Allow the judiciary to determine what is priority. What's their priority? Let them be the one to build houses for themselves, buy cars for themselves. But there must be proper auditing and monitoring also to ensure that there is no abuse, right? Because why they are saying that some of the chief judges may have been involved in abuse of usage of funds. And that's why they now say, let's get them out of this and all that. But you must monitor them. They are human beings themselves also. They must be monitored, but don't allow the governors to be the one to detect the priority for judicial system. And if they do that, they really, really, really impairs on the independence.
The former head of the Nigerian Human Rights Commission did write an op-ed on this, which he tagged the Minister of Judicial Welfare. He was referring to these gifts and...
We've been talking about independence of judiciary right from my days in university. Now we're still talking about it, but we're going to break. When we come back, I want us to now visit the conversation about certificate forgery and resignation from office. We'll be right back. Welcome back to Breakfast Central. We're still looking at the judiciary, but this time around we're taking a different turn with the conversation. We're speaking with the learned SCN, Monday Ubani. And this time around we're looking at the resignation of the Minister of Innovation, Science and Technology, Geoffrey Uche-Naji, after the allegations of a forged certificate. So let's come to you, sir, and talk about what the implications of this are. On the one hand, he's still claiming. We saw his position and his resignation letter. It says that if we have that, if our team can please put that up. He's saying it's malicious. They're trying to tarnish his image. It's basically politically motivated. How do we balance that with the investigation that was carried out, with the university saying clearly that they did not issue him a certificate, and then also taking note of the presumption of innocence?
Yeah, he's presumed innocent. If you've been talking about crime now, until proper investigation is done and then charges filed and then there is prosecution and conviction, he's still innocent in the eyes of the law. But the position is that I had wanted a proper explanation as to the certificate he presented. That's only issue to me. Or for every other issue, yes, you said it is malicious. You say that probably the Vice Chancellor is now a politician in the garb of a professor, and he is used by their political enemies. But the point is that you presented a certificate.
Where did you get
that certificate? Is it from the and I think he felt that honorably, the best thing to do in the circumstances is to resign. Are you following me? Nobody knows. So doing that for me is an honor to him. I respect him for that. Instead of dragging the matter, I listened to his man, on television yesterday. I sat down to listen to a better explanation, to really give me explanation as to that certificate he presented to the Senate and to DSS. Who gave it to him? Is it the university? I wanted him to say it's university, but they were not. They were looking for the script, for the they call it the result. The result is different from the certificate. The certificate now qualifies you as a student who has graduated from the university. But when you talk about transcript, is when you are probably applying for masters or for PhD. They want to see the results of all the subjects and all that. That's where transcript is very valuable. Yeah, INE doesn't. It's certificate they require. So since you now was employed as a minister of the Federal Republic of Nigeria and you tendered a certificate, that certificate, where did you obtain it from? That's on. And he felt that if he has no explanation for that certificate, that the best thing for him to do, I just kudos to him. I respect him for that, for putting in his resignation. Whether the state will want to prosecute him is a different matter entirely.
It's only the state that can institute criminal proceedings against him for forgery.
Yeah, you can also lodge a complaint as an individual, but I think investigation of crime is only done by a security agency. It is that security agency after investigation can say, look, this particular, a prima facie case has been made out. Because if you are alleging forgery, you must prove that there is original. You must prove that the document is in writing. You must prove that the alteration or fake was done by the maker, by the person himself. This man you want to charge, you must prove that
is presented or presented.
All these are elements of the offense. It must be the person that who may have faked it. You must those things must be present in any crime of forgery. Now the issue now is it him that did it or somebody tendered it in his
went to apply to
he was one that
somebody facilitated a forged certificate for him.
So that's why I say it is safer for security agency to be the one to actually be in charge, investigate, and if a prima facie case is made out, charge him if they want to charge him. If they want to charge him. But people are insisting that he must be charged. But the point is that would the state be willing to charge him in the circumstance? But for me, it's a mark of honor for him to have tendered his resignation. I love him for that, and I appreciate him for what he has done.
Is it really a mark of honor, or he shouldn't have presented in the first place? Yes.
When it came to the realization, no way out.
It was game over. It was game over. Yes.
Some people.
We've seen it in the past.
And because now I said no, nothing will happen and all. Are you following me?
Yes.
But look, the best thing for me in this I don't want this controversy, and I'm sure he must have been prompted to. And the president was willing to accept this and say thank you for the services you have rendered so far. But for now, step aside, and which he did. Honestly, to me, I respect him for that. You may disagree with me.
But the issue is, this is not the first time. Even the president was accused of forgery. They've accused a number of politicians of forgery. Kemi Adeosun, a number of people.
Kemi resigned honorably and went back to London and all that. So to me, it's a mark of honor for somebody who knows that he has no explanation for any impropriety and say, look, the best thing for me to do in this circumstance. To me, I respect him for that. But whether they will want to prosecute him is a different ballgame.
Okay. I think maybe my final question in regard to that would be for those who are saying, a pushback to your response might be because they are public officials, they are held to a higher level and a higher standard of integrity. So should it be if they want to prosecute, or should it be there must be an investigation? And like you said, if there's a prima facie case, there must be a prosecution.
Now, if the government feels that let's use this as an example. Obasanjo did it with one of his ministers who committed one level of impropriety and all that, and it took him to court and he was charged and convicted, right? Now, if this government feels that, look, this is not right, we must correct this and all that, then they can initiate. Are you using him as a precedent? Yeah, that's what I mean. It's the government that will take that decision. Yes.
Now, finally, there's been talks about the judiciary. They say the judiciary is no longer the last hope of the common man. The phrase "go to court" became catchword in the aftermath of the 2023 elections, and ordinary Nigerians, the masses, feel they can no longer trust the judiciary. They feel it's politicized and they've lost some of their credibility. How or what work does the Nigerian judiciary need to do to restore confidence and faith of the ordinary Nigerian people?
The of the confidence started with the Attorney General, with major stakeholders in that sector, the NBA, and even the CJN. They are all worried with the loss of confidence on the judicial system, and all is being done in terms of reform, both statutory and procedural, in order to give people some level of confidence. Quick dispensation of justice is key. Recruitment process is also very key. I'm talking about the personnel now. They're saying, look, let's follow the process of allowing input from the members of the public. For now, if you are nominated to be a judge or you are, they must have input from the members of the public. This personality, what do you have to say about that? That's the process. Yes, they are doing it now. They are asking people now to write and all that. So that again is part of the process, of ensuring that, look, we have to restore the confidence. An issue of enforceability, which is what you mentioned. Because when you don't enforce judgment, so why do I have to go to court? Beautiful. Why do you have to waste time, years? If I file an appeal, it takes up to 10 years for the appeal to be heard and all that. So these are the reforms that people are looking at. I said, listen, we must correct this, or else people will begin to take laws into their hand and lose confidence in the judiciary, and it's going to affect the investors who want to come.
All the stakeholders,
my brother, the CJN is involved in the Attorney General, the Nigerian Bar Association, and all other major stakeholders, the government themselves, in terms of funding and independence, they're all getting involved. I say, look, we must get our judicial system working. Look at Singapore, look at South Africa, look at Kenya. They are all far ahead. So what is wrong with our system? And so they are now putting those reforms in terms, even constitutional amendment is taking care of most of the things. And one of the most important reforms is the issue of not allowing every matter to go from the lowest court to the Supreme Court. They want to limit it. Things that go to Supreme Court. They want to also increase more of the judicial division of the Court of Appeal. So a lot is being done presently by the present government in terms of reforms of the judiciary in order to ensure confidence is restored. Yes.
We want those reforms to kick in and to see that there's result and it moves from policy to implementation. Thank you so much, sir, for joining us. It's always a pleasure to have you.
And this is a beautiful place you guys have here in Abuja. I'm so pleased. When I heard that you're in Transcorp, I said, New Central, it just came up. You guys are bubbling. Honestly, I'm proud. I'm proud of you guys.
That's very kind of you to say.